We'll go ahead and get started and welcome everyone. And my name is David Taylor, and I'm an attorney with Twin Falls Estate Planning. And today we're going to be talking about how to estate plan. And I wanted to talk about this because I get asked a lot about what is estate planning. Actually, really what happens is a lot of people ask me, what do I do? And my assistant can attest to this, but about once a week I get asked, are you an attorney or something like, hey, are you practicing law on the side? And so, often the conversation goes, if I tell someone what I do, I say, oh, I'm an attorney. And they say, well, what kind of an attorney are you? And I say, I'm an estate planning attorney. And then it's like, oh, okay, yeah. I get that most people don't know what this means. And many people probably go on through their lives without knowing what estate planning means. And so I wanted to just talk about some of the basics, some of the fundamentals of estate planning, and hopefully give you some tools that you can use to decide what to do about your own estate plan. And you'll find out pretty soon there's already an estate plan in place for you that the government set out, and maybe you like it, maybe you don't, but that's the purpose of this. So I just want to make sure I help people get into the right direction. So with that, I'm going to turn off my video and we will continue on. So just a little bit about me. So I'm an Idaho native. I grew up in the Boise Meridian area, and my wife is here, and she's here from Twin Falls, and we were married here in Twin Falls. So I kind of consider myself like an adopted native of Twin Falls, something like that. But we lived in Meridian for a while, and a few years ago we moved here to Twin Falls, back where for home for my wife, and we have 2 kids, and they are 4 years old, and they are twins, and they are here in this house. We're all working remotely, so don't be surprised if you get, you hear 2 kids run in and I have to yell at them. That's what's going on. So hopefully not, but you never know. And as far as here's a picture of them too. This is us at the front of the Perrine Bridge about a year and a half ago. So we love it here in Twin Falls. As far as a little bit about my professional careers, I interned at an estate planning firm in Eagle, Idaho. It's called Idaho Estate Planning, and the attorney there is Mark White, and he's a great attorney. And after my internship, I asked him, what should I do with my life? And he said, go be an attorney. And I said, well, great, that doesn't help much. And so his advice was to go out and be a conventional attorney. I figured out later. And so that's what I did. As I was a litigator, I was your guy to come to sue someone, and I hated it, and everyone hated me. And so I got out of it as soon as I could. But I'm grateful for that experience I had, because that led me to where I am, which is I love doing estate planning. So basically, the firm where I interned at, I stole all of their ideas and I started my own firm here in Twin Falls and haven't looked back since. So that's just a little bit about me, and we'll go ahead and we'll start talking about estate planning. And one of the first things to note, this is a typical cynical attorney thing to say, but just want to make sure that what we're talking about today is not considered legal advice. This is just practical advice. I really want this to be an educational experience, is what the goal is. And it's really trying to get you to take the right step take a step in the right direction. So use this knowledge to do that. Use this knowledge to know where to go. Perhaps maybe you're looking for, how do I start, and use this knowledge for that, or to win bar trivia games, something like that. But this is not legal advice, just so you know. So as far as what we're going to be talking about what estate planning is, and then we're going to talk about some options for estate planning, what you can do, followed by some of my advice. And you'll be surprised, we're going to spend quite a bit of time just talking about what estate planning is, because I find most people don't know what it is, and that's okay. Not something you exactly learn in school. But let's start with the basics, and let's just talk about what an estate is. When we think of an estate, I'm sure this is what we think of. Those of you who are on the call, this is a picture of Downton Abbey and the manor there. And when we think of an estate, we think of someone who has lots of money, lots of wealth, and of course they want to make a plan for that. But what it really means is it's the stuff. It's our belongings, it's our bank account, even if we only have $1 in there, or it's our home, even if we own a mortgage on it. doesn't matter as far as what you have. All that matters is that you have property. And so long as you own property, you have an estate. And when it comes to estate planning, really what you're doing is you're making a plan for your stuff. I jokingly say I could have named my firm Twin Falls Stuff Planning, but it doesn't really make a lot of sense for an attorney to have that name, but that's really what it is. A lot of people to me and they say, I don't have anything. And, that's fine. If you have property, I mean, you have stuff and you can make a plan for what happens with your stuff. But here's the thing is when it comes to estate planning, it involves the law. And you'll find as we go throughout this that the laws in Idaho will have an estate plan for you. And if you don't like that plan, then you need to know what the laws are so that you can change it. And that makes sense a little bit later, but I'd sometimes call estate planning legal planning because really what we're doing is we're creating a legal plan, whether it be a will or a trust or power of attorney, all sorts of documents you might have heard of. Ultimately, they are a legal plan on what you're going to do with the law. So as far as estate planning goes, I look at it as two types of planning. First is the plan by default. So staying on our subject here, that the government has a plan for you, and it's a one size fits almost no one plan. And ultimately, the plan is that a judge has to rule on what happens with your property. What might look like, there's incapacity where you can no longer think for yourself. And ultimately, a judge has to rule on that. The judge says, that's correct. You cannot think for yourself, and someone else needs to be able to take care of your assets. Or when you pass away, the judge has to look at your property and say, yes, that's correct. And here's how your property is going to be distributed. And that's what the plan is from the government. And that's because, we don't know how to plan for you. But we have to have something. There has to be some kind of mechanism, some law in place for what happens with you and your property. And that's what I call the plan by default. So unless you make some kind of plan to change otherwise, then you are subject to the plan by default. And that might be another topic for another day, is talking about what that is. But for the purposes of our conversation, just know it's a plan that says the judge decides what happens with your property. So the plan by design is how you curtail that, is to say, no thanks. I think I know what's best for my property. And you have probably heard of some of these documents, but the plan by design means you have taken it into your own hands to determine what happens with your property. And you might have heard of these before. This can be done in a financial durable power of attorney. That has to do with incapacity. That determines when you're incapacitated and who can take a hold of your assets, what they can do with it. Last will and testament. Last will and testament basically is the plan for what happens after you pass away. And talk about this just a little bit now. A will does not avoid these court proceedings. And that's one of the very common misconceptions I hear a lot, is I'm doing a will so that I don't have to give the money to the government, or I don't have to go to court. You do. You still have to go to court if you have a will. You just direct the court proceeding on how you want it to go. Advanced healthcare directives, that's something that, again, plans for incapacity. What happens when I can't think for myself? End of life decisions and things like that. Revocable living trust. That's the document. That's one of the most powerful documents of them all, which basically takes your plan and you make your own terms and you stay out of the court system completely. So another question I get a lot is, what's the difference between a will and a trust? And there's not an easy answer to that, because you've just asked an attorney to open a can of worms and breathe all of my knowledge I learned in law school upon you. But what I simply say is a will ask a judge what to do with your property. Sorry, will tell a judge what to do with your property, and a trust makes sure that there's no court proceeding on what happens with your property. That's basically it in a nutshell. We're going to talk about these a little bit more. So let's talk about first incapacity. And incapacity, we're first going to talk about what happens with your finances. So what happens when you can no longer make a decision for yourself? without a comprehensive plan, we have to have this hearing. It's a lawsuit. It's called a guardianship. And someone, probably a child, a spouse, someone has to sue you and take you to court and say, mom is not able to think for herself anymore. And I want to be able to think for yourself. And the judge says, okay. And that commences a series of tests and a whole bunch of things come into play, and then people come back to court, and then there's all sorts of things going on. But ultimately, this is about a $5,000 court proceeding to go through because it's very expensive. A lot of things you have to prove, and then ultimately the judge determines whether you can make decisions for your finances. And if the judge deems that you're unable to make decisions for your finances, then the judge appoints someone to be your guardian. The judge appoints someone to be your conservator, and someone else is making decisions on your behalf. That can easily be changed. That's when we would talk about a power of attorney document, but that's the general plan. Again, if you don't have a plan in place, that's the government's plan for you. Sticking with incapacity, let's switch gears to talk about healthcare. And sometimes I get this question of, do I need an estate plan? Maybe someone comes to me and they say, I don't have a lot of stuff, or maybe they come to me and say, I'm single, I don't have any kids, what do I care, that type of thing. Well, we still care about you, and there could be a situation, heaven forbid, but there could be a situation where you cannot think for yourself as far as your medical decisions. And maybe an estate plan could be a good fit for you. Maybe you don't need a will because you don't care what happens to your property when you die. But maybe you should have some healthcare directives as far as what happens in situations such as end of life scenarios. You're in a vegetative state. You can no longer think for yourself, and death is imminent, and your brain dead. And what happens then? In fact, one of the very first cases about this happened in, I think, 1978, 1979. I believe her name was Nancy Cruzan, who was a 19-year-old college student, a single girl who was involved in a car accident. And at that time, the medical technologies were advancing, and the medical staff was able to keep her artificially alive. And the parents objected to that, but there was no law that allowed the parents to object to that. So all that to say is, many people come to me and they say, do I need an estate plan? And the answer is almost always yes, of some kind, because you never know what could happen. Again, that was a girl who was 21 years old and life was going well, and that happened. And very heart-wrenching story if ever you are bored, which you might be with all that's going on right now. But basically, when it comes to planning for your healthcare decisions, we're trying to tear down some of these hurdles. So going back to Nancy Cruzan, there was no law that allowed the parents to make a decision. We craft it, there are now, but we craft these documents to make it easier for the healthcare professionals to work with your family and tear down those barriers, so they know who to contact, they know who can make those decisions. And to me, that's more important than anything else that we do, because if a client comes to me and pays me money, I appreciate that, and we'll take care of their things, but I care more about that client than their money. And we want to make sure that we have this in place so that if something were to happen to you, we can take care of you. If we get something wrong with your money and you lose your money, life still goes on, and you might be able to recoup your money. But we say in the law, money is fungible, meaning you can destroy your money and life goes on, but we care more about you and your health directives. Okay, so now let's switch to a happier topic, which is death. I don't know if that's a happier topic or not, but it's something that's inevitable. Some of these other things we're talking about may not happen, but to the best of my knowledge, this is inevitable. And without a plan, the government decides who will receive your property, and that's through a process called per stirpes, by representation. You might have heard that before. Maybe you spoke with your financial advisor and they were telling you about how your property is going to be distributed. And if you look at this law, it's actually not too bad on its face. And I sometimes hear this from, I'm going to pick on accountants, even though I know there's an accountant in here. But sometimes accountants look at this and they say, hey, that's not bad. You know, we're just looking at one side of the picture here. So basically, the law says that if you're married and you die, everything that you own goes to your spouse. If you don't have a spouse, then everything goes to your children. And if you don't have any children, then all of your property goes to your parents. And if you are unmarried, you have no children, you have no parents, then everything goes to your siblings. That's basically what per stirpes is. But what you need to understand is that doesn't fit everyone. Remember when I said that the government has a one size fits almost no one plan? You think about what are families looking like today. Let's start with blended families. These are step parents, stepmom, stepchildren, and you have a scenario where mom has kids, dad has kids, mom dies, and all of her stuff is left to dad. Dad dies, and all of his stuff is left to his children, and mom's children get cut out. So there's that to consider. Business owners, if you own a business, an estate plan is essential for you because business needs to move on, and you don't want your business to get caught up in a court proceeding trying to figure out who's going to take control of your business. But also, you may not want your children to take care of your business. This is typical of farmers. In almost every farmer who's come to see me, the conversation goes something like this: I don't want my kids to get the farm. They haven't worked on the farm for years. They left the farm when they turned 18. I want to give it to my employee. You know, there's always someone else that they want to give the farm to or their business to, because usually the kids are off and gone. So that's something to consider. Minor children, if you're a parent of minor children, or if you want to give any money to minor children and there's a court proceeding, that's an awful process and a very costly process because the children are under 18 and they cannot represent themselves in court. Same thing with your retirement plans or life insurance plans. If you give those to your children, then that's just going to be an awful mess because they're under the age of 18 and there has to be conservatorships. Spendthrifts, what if you happen to have a child or an heir who is on drugs or in jail? I get that question sometimes. And there's provisions you can do to safeguard them from getting a whole bunch of money. Special needs is unfair. And what I mean by that is usually the way it works is you could end up giving all your money to the government. In a very long story short, someone who's on special needs usually has a government benefit, and the government requires that person to pay back the government if they ever receive a lot of money or I guess be ineligible for their benefit. So families with special needs, my heart goes out to them because they're in a difficult situation to begin with, but the laws of Idaho are not very favorable to them. And I don't mean to make it sound like I'm anti-government or anti-establishment. I don't have a better solution of how to change the laws other than to do something about it, to get a plan that prevents this. And most people with special needs children, when I tell them, you're going to end up giving your money to the government, they seem to appreciate what I tell them so they can at least have the option to prevent that. So now let's talk about how this is administered. We just talked about what happens, but how is this administered? It's administered through this process called probate. And that's a very common term. I'm sure people have heard it and wonder what it is. And I get that question a lot, and we don't have the time to go deep into it, but suffice it to say, probate is a lawsuit. So when you pass away, and even if there's a will, we have to have a judge sign off on how your property is going to be distributed. And that's what the court proceeding is called, is probate. And that has to be done even for spouses. And some exceptions apply, but that's the general rule, is when you pass away, then someone needs to go to probate to get all of your stuff to your spouse, even in Idaho, which is a community property state. Probate costs about $2,500 in legal fees, and that's for an uncontested case. That means no one's challenging it. Closer to around $3,000 for a couple. So, take that into mind. I jokingly but truthfully say that attorney fees are inevitable. Either you pay an attorney to make a plan for you, or you pay an attorney to execute your estate when you pass away. But the thing I hate about probate the most is it is required by law to take 6 months. And that's a long time for someone who's grieving to go through a court proceeding and to talk to the lawyer and get billed every time by, the bill by the hour every time. And to, I work with trust too, and I do a lot of trust. And sometimes it takes 6 months anyways to get everything administered, but at least, you have options if you make a plan otherwise. With probate, you don't have any options. It has to, by law, take 6 months. And that's a very long time, in my opinion. And actually, sometimes during those, I get bored. Right around month 4 or 6, 4 or 5, we're done with most of what's going on, and we just want to end it. So now let's talk about what you can do about this. So I just explained to you what the estate planning is, what the government's plan is, and here's some options of what you can do to fix that. So I call these plannings type A planning and type Z planning. We'll talk about those in a little bit, but plan A planning is basically a plan that could work. It's not a very in-depth plan, but as long as everything goes to plan, meaning there's no life changes, you'll probably be okay. What does that look like? A holographic will is an example. And so in Idaho, you can sit down and handwrite a will and sign it and date it, and that can be probated. Is that good or bad? Well, it depends. I do have 2 stories about that. One story where there's a holographic will where a brother wrote to his brother and said, hey, if I pass away, here's who I want to have happen. And that was taken to court and probated, and that was just fine. Contrast that to another story where same thing, it was a letter, and that was, we were the 6th attorneys on that case, and it was just a mess. And, it just really depends. It could work, it could not. It's probably not going to work. Let's talk about that a little bit more. Do-it-yourself estate plan. So you could very well just walk into Office Depot and find a do-it-yourself kit. And a few things about that. Same with the holographic will. I have never come across one of these plans, whether it be a holographic will or especially these do-it-yourself plans where someone goes through like a TurboTax type of thing where they go through some interviews, answer some questions. I've never seen a plan like that fully accomplishes a client's objectives, whether it be a client who comes in to ask me questions about their plan, or whether it be someone who's passed away. There's always something wrong. I've seen money going to ex-wives. I've seen money going to unknown children, just all sorts of things that could possibly happen. And again, I've never had someone come in and say, here's my do-it-yourself kit. And I looked at that and I said, that's awesome. You're going to be just fine. There's always something wrong that does not accomplish their objectives. And lastly, simple plans. These are estate plans, which are done by non-estate planning attorneys. So I proceed with caution because I don't mean to speak ill of my colleagues, but I, in my experience, have found that non-estate planning attorneys, well, let's say this, litigators are not always the best planners. I'll just leave it at that for now. And really, when it comes to estate planning, you should start with someone who specializes in estate plan and see from there. So plan A planning, those could end up being more costly. They may have low upfront costs, but they have the potential to be more costly in execution. Some other problems is they may not accomplish your desires, and I talked about that, is even if you can get through the administration costs, you might not have your assets going to the right people. But more importantly, life changes, and those plans, those plan A plans, may not account for what happens in the future. And plenty of times I've seen people who did a will 30 years ago, and then one of their children passes away before them, or something happens. And here's another one, remarriage. That happens a lot. I did a will 30 years ago before I was married, or I did a will 30 years ago when I was married to my first husband. Life changes, and there's ways that you can plan for those changes. So some of the takeaways from Plan A planning is they're attractive, but my biggest issue with them is that if you're doing these on your own, you don't know what the law is, and that's why an attorney comes into play with this, is because the attorneys, especially estate planning attorneys, we know what the law is. We've seen these things firsthand. I hope what I'm saying is it's not hard to sit down with a piece of paper and say, I know who I want my property to go to, write a few things, and that's it. But what you don't know is these laws and these implications and what you're really doing. So it's a craft is what it is when it comes to doing estate planning. And like I said before, in my opinion, litigators don't make the best planners. I'm not a litigator. I don't like going to court. And I'd rather plan and use my experience that I took from litigation to use it to effective planning. So I have a story about some type A planning. And this is a story I call the three bridge players. They were three of the sweetest ladies, one of whom I only ever met. And they were just older in life. All of them were married at one point, and either they were divorced or their husbands passed away. But this was just much later in life when they met each other, and they became best of friends. And they all had names that start with J. And there's Joyce, Joanne, and Judy. And Joyce was involved in a automobile accident, and she wanted a settlement. And I think it was over $1 million. Just she made out pretty nice on the settlement late in life, and she decided that she was going to take care of her two other friends to, make sure that they have a good life so that she can provide for them. So this is what she did. She decided to do a plan. We'll call it a plan. It wasn't a very good plan, as you're going to find out. But perhaps the worst part about this is it was a plan done with an attorney. An attorney who's now retired, so they were experienced in it. I'm not sure what happened, but here's the plan. Is Joyce said, when I die, I want my house to go to Joanne. Okay. Then the money that was kept in an investment account, she says, I want half of that to go to Judy. All right, so she's taking care of her three bridge playing friends. And then the other half of that investment account, so we're talking around $500,000, she's going to divide that up, and part of it's going to go to her grandson. He's going to get $50,000 for school, and then he gets another $50,000 at the age of 25, assuming he's done with school at that point. And the remaining half is going to go to charities, and also it's going to pay for, Joyce's expenses, make sure that all of her bills are paid for, the attorney fees are paid for, and just make things easier for when she passes away. So what ended up happening is this. Sorry, I just got a message here. Probably won't be able to see the right side of this. Let me try. You might need to adjust your screen a little bit if you can see it. Okay, so here is what happened. Sorry, I skipped ahead a few slides. Let's start first with part one. This is grandson's share. And grandson, because the way the plan was written, grandson ended up getting the entire investment account. So remember, he was only supposed to get $50,000 for school, then $50,000 once he graduated. He got 10 times that amount at the age of 19. And the charities got nothing. And also, no expenses were paid. That's going to come into play here in just a little bit. So that's part one, and bear with me because there's always twists and turns in my stories. And part two is what happened with Joanne's house. So Joanne was receiving a government benefit. And remember when I said before about special needs, she was technically special needs, but there was no special needs provisions. So she was deemed ineligible for her benefit. Now, the other problem was that Joanne had to hire an attorney to get the house and probate the house and do all of these things, and also Joyce had some debt still for whatever the reason, and so Joanne ended up having to get a reverse mortgage to pay for all of these things because she did not have any liquid cash on her. She did not get any liquid cash from Joyce. She just got the home, but that was the only way she could get the home, was to effectively lose the home and get a reverse mortgage so she can pay for, for her to get the home. Part 3, let's talk about Judy. So Judy, as you may recall, she was supposed to get half of the investment account, and the other half was supposed to go to the grandson and the charities. And Judy did, but Judy died less than a month after Joyce. And so now we're going to talk about Judy a little bit. Judy had a do-it-yourself will, and she drafted the will shortly after learning that Joyce was going to give her an inheritance, and named 7 beneficiaries in her will. So Judy, this was back almost 10 years ago, and life went on. And I'm sorry, the car accident happened about 10 years ago, and life went on, and Judy decided that some of her heirs were being greedy, and so she started making changes to her own do-it-yourself will, and those changes were ultimately deemed invalid. And so her estate, when Judy passed away, which again was Joyce's investment accounts, were ultimately paid out to those 7 original heirs, and many of them were unwanted heirs. Judy just didn't do it right. And in addition, Judy was also on Medicaid, and she was on Medicaid for years. And when someone is on Medicaid and they pass away, then you are required to pay Medicaid back for your bills. And so Judy ended up using Joyce's money to pay back Medicaid, and it was 6-digit figures. It was quite a bit of money because Judy was on Medicaid for years. So let's look again at this plan. Recall that Joanne was supposed to get the house. Judy was supposed to get about $500,000. The grandson was supposed to get about $100,000. Charities were supposed to get money. Expenses were supposed to be paid. And ultimately, the house went to Joanne, but with strings attached. Joanne lost her home. She's going to lose her home upon her death. She's not going to be able to gift that to anyone. And Judy, the other bridge player, she died before she could receive her inheritance, and her money, the $500,000, ultimately went to both wanted and unwanted heirs. The grandson got $500,000 at 19. That's probably going to ruin his life. Hopefully it doesn't, but that's a lot of money to give to a kid with no strings attached, and charities got nothing. And the main thing is, of course, that all of this could have been prevented without proper planning. And with proper planning. So that's the hardest part about this, is to look at this and just say, man, if you would have just gone to see a specialist, yeah, it may have cost a little bit more up front, but everything would have been taken care of, because these were all simple fixes. It's not hard to put a special needs provision in there. I don't know why there wasn't one in there. And it's not hard to do what Joyce wanted to do. It just wasn't done, because they took a lot of it into their own hands and tried to take the simple path. So with that, I want to talk about some of the best advice I can give you. And the best advice to give you is to find the right plan for you. And it doesn't necessarily mean to spend more money. It just means doing your research, doing your homework, and find the best path to begin your plan. It's a lot like shopping for a car. Do you just walk into the car dealership and say, I want the best car money can buy? For us, it's like going to a car dealership and saying, oh, we want an SUV, and hope you have a good car salesman who's going to say, do you really need an SUV? Do you go off-road? And you say, well, no. And then the car salesman says, well, don't you have a bunch of kids? And you say, well, yeah. And then the car salesman says, yeah, I should probably get a minivan. It's just a matter of, you need to find out what's best for you. And a lot of people get caught up in these documents. What's a will? What's a trust? Do I need a trust? How much does a will cost? How much, I get these questions all the time, and they're hard to answer because I don't know someone's individual scenario. If you were to ask me what's better, a will or a trust, I'm going to tell you a trust, because there's a lot more things you can do with it. But a trust is not always the most applicable situation. If you are not going to be subject to probate, then probably a trust is not the best way to go. It's just a conversation I need to have with people so I can tell them that ultimately the right document is the one that's going to fit your plan. And so that's involving a process of, you need to determine what you want to have happen with your stuff. And not only that, that's probably easy, but how do you want to effectuate that? How do you want your plan to be administered? Do you want to go through probate? Do you care? These are things that you need to decide when it comes to your estate plan. Then come up with a budget. Estate plans range from a few $100s to a few $1,000s. And I'll give you some, like just for me and my prices, they range anywhere from 500 to 5,000 for plans without getting too complex. And so it just depends is the short answer. It depends on what you're trying to look for. If you are, for example, a young couple and your primary concern is naming a guardian for your children, then probably the cheaper plan is fine, because you're not concerned yet with what happens to your stuff. You're more concerned with, I just want to do whatever I can to make sure that the right guardian is named for my child. Great, that's the plan. So here's a good rule of thumb for my prices, just ballpark ranges. But a good plan for a will for a couple, if you really want to make things simple when it comes to a court proceeding, probably going to be around $1,500. If you want a plan that avoids probate and puts together a good plan for incapacity and death and keeping everything out of court, you're probably looking at about $3,500, which, compared to, remember what I said before, probate for a couple is $3,000. So actually, if you end up doing a will for $1,500 and do probate for $3,000, I mean, some of these plans could end up costing you more in the long run, which again is not bad as long as you know that going into it. That's the main thing. Is I talk to clients many times, and I'm one of the nice guys, I think, and I tell them that, and I say, this, you're probably going to end up paying me a few more times down the road, and they're okay with that. So that's fine. A comprehensive plan where you want to start getting into more of the advanced planning, but some good planning that can take care of your surviving spouse, cost around $5,000. And that's a very good plan. I call that the Married for Love Trust, where you can make sure that the assets are preserved for your spouse and that your spouse is not going to blow it, in case there's medical bills that stack up, or in case there's Medicaid involved. And so the best advice I can give you, I think, is to start with talking to an attorney. Most attorneys offer a free initial consultation, and I think that's just a good way to go, because in general, I think you're going to be better off talking with and working with an attorney rather than doing a do-it-yourself. And the main thing is, if you don't like that attorney, especially if they're doing a free initial consultation, or maybe you just don't like their plan, their route, you're not obligated to it. At least you've heard and you know what the options are. You can go on from there. So I think that's a great start, is to talk with an attorney. My preference, though, is to find an estate planning attorney. And this happens very often as I talk to people about their estate plan that they've done with an attorney. And I feel bad doing this. I tell them this is not a good plan. And, the conversation usually comes up, who did this plan? Oh, Uncle Bob, or, this guy, I saw this attorney for my car accident. He seemed like a good guy, so I went back to him to do my will. And, like I said, litigators are not always the best. Think of it this way. If you wake up with a backache, are you going to go to see your chiropractor, or are you going to go see your oncologist? You know what I mean? It's just a matter of going to see the right attorney. So if I had a choice, I would say start with an estate planning attorney. And like I said, if you like him or her, great. If not, then at least and you have some options. But no matter what you end up doing, whether it's a do-it-yourself will, hologram, whatever it is, perhaps the most important thing you can do is communicate that with your family. Tell them your hopes, fears, and desires. Have that conversation. It's not pleasant, but these things are inevitable. And talk to them and say, hey, if something were to happen to me, here's what I want to have happen. And that can avoid a lot of conflict. And a lot of times that can overcome these bad estate plans they come across. In fact, even just today, I was talking with an heir of one of the cases I'm probating, and told him, this wasn't a very good will. And he said, yeah, but this is what Mom wanted. And, we're okay going the way mom wanted. And I'm like, well, the will doesn't say that. And he says, that's okay. We'd rather do what mom says. Okay, well, we won on that one. There very well could be all sorts of conflict and things coming up with that, but they accepted it because their mom had communicated to them what she wanted to do. So that's my advice to you is of course find the right fit for you and communicate that with your family as far as what you want to do. All right. Well, I want to thank everyone for coming. And if you have any questions, you can feel free to contact me. And sure you saw the website. If you can email me to David at tfestateplanning.com or give us a call 208-733-7200. Other than that, thank you all for joining and have a good weekend, good Easter, and take care and be well out there with all of the chaos going on. Thank you.